Welcome to my podcast, Family Law Uncensored. I'm your host, Maya Shulman, family law and family practitioner, attorney. Also do mediation and pre-post marital agreements. I'm very much believer in the out-of-court settlements, and that's what I try to accomplish with my uncensored and unpopular opinions. Today we will be discussing IVF surrogacy legal implications, lack of information in the world, and information that I'm hoping to provide you with. IVF is a semi-scientific term. It's an acronym that stands for in vitro fertilization. IVF applies to individuals who are unable to conceive by natural means. I will also tell you that the World Health Organization has declared infertility to be an illness. Out of 10 couples, 6 have issues with fertility. And if you look at the numbers, sheer numbers, that is a huge number of people who cannot conceive by natural means. So IVF is one way to get to having a family. IVF is one of the ways that people use to get pregnant, and IVF is one of the ways that I will teach about in my class. Donors of genetic material, be it an egg or sperm, have no legal rights. They are just that, they're donors. And the donor donation agreement will state that language, that you provide sperm or an egg, and you understand that you will have no legal rights or responsibilities if your sperm or egg results in production of a human being. It's important to know that in California, this has been the law, that the sperm donor is just that. And sperm donor, his role stops with donating the sperm. So the sperm donor can only assert parentage if there was a subsequent contact, subsequent paternity action, if there was something else that has happened after sperm donation took effect. In the absence of that, again, a sperm donor is just a donor, and he has no rights or responsibilities to any future child who may have been born as a result of his sperm donation. First and foremost legal step that a couple or a single person should undertake before beginning any fertility treatment, they have to have a legal contract signed with, number one, the clinic, and then number two, with either a sperm bank or a donor of maybe a gamete. A gamete is a fancy name for an egg, and gamete comes from a Greek word that stands for wife. And that's an easy way to remember fancy terms. Gamete is a wife, and gamete is a genetic material that one will obtain necessarily, but maybe, when going through in vitro treatment. To determine legal parentage of a child born through IVF, the courts will look, number one, at the contract, which is a requirement in any surrogacy procedure that has to be signed before the very first fertility treatment. You have to have a signed contract. Also, by law, each party to a surrogacy treatment, to a fertility treatment, has to have independent legal counsel. It's not negotiable, but it's indispensable. You have to have it for your protection, you have to have it for the clinic's protection, you have to have it for the donor's protection, and you have to have it for the surrogate protection. So unfortunately, I will have to tell you, you have to have this with a lawyer present in your life. There are some famous cases that I also teach about in my class. One of the cases has to do with the actress Sofia Vergara. The main takeaway from that case, first of all, that case originated not in California. That case originated in the state of Louisiana. And as I tell my clients and my students, things are different outside of California and New York and other big states. What is different about Sofia Vergara's case, first of all, in Louisiana, embryos are given the statehood of a human being, not in California. But in Louisiana, because those embryos are considered humans, don't know why, didn't ask my opinion, I wasn't there. However, because they were considered to be humans, they had the right to sue their mother. They had the right to sue Sofia Vergara, and they did through their appointed counsel. So the lawsuit from the embryos, and they had names, the lawsuit from 2 embryos against Sofia Vergara was because she deprived them from their life. She did not want them to become humans in the full sense of the law. And that lawsuit lasted about 4 years. The second portion of that lawsuit had to do with Miss Vergara's then boyfriend, who wanted to use frozen embryos to implant them to somebody else's body to have them become full humans. Now, at the time the lawsuit occurred, Sofia Vergara and her boyfriend were not a couple anymore, and the lawsuit originated because there was a disagreement about what to do with frozen embryos. And as I teach in my class, one of the most important things to look at, and what the court is going to look at, is the intent of the parties. If there's no signed contract about the intention of what happens with frozen embryos when that couple is split up, then the court is tasked with a burden of determining what happens with the frozen embryos. And like I said, that lawsuit lasted a long, long time. It cost them a pretty penny, and it finalized with Sofia Vergara prevailing and not allowing her now former boyfriend use the frozen embryos to implant in someone else's body who is not Sofia Vergara. The legal protections for same couples going through IVF is the same legal protection that are available to everybody else. You have to have a legal binding contract. You absolutely have to have it. You have to have independent legal representation. You cannot do without. And attorneys become indispensable, especially when we talk about surrogacy. Now, also remember, different states have different laws. Family formation laws are state specific, just like adoption is state specific, just like family law in general is state specific. So before you do any fertility treatment or adoption, before you embark on that journey, you must have legal counsel from the state where you're going to go through this process, because the laws are going to be different in every different state. Also, you have to realize that now with the politics and new decisions that came from the Supreme Court, and I'm specifically talking about decision that came down in Alabama, you have to know the laws that may impact you in the state where you're going to undergo fertility treatments, because those laws will determine your rights and your responsibilities in the surrogacy process. In the surrogacy and fertility process, when you are undergoing fertility treatments and then hopefully it culminates into you having a baby or two and having a full family, lawyers are there to protect you. Lawyers are there to protect your babies. Lawyers are there to make sure that the process has integrity. Lawyers are there to make sure that the clinic fulfills its obligations towards you and your future family. Lawyers are there for your protection. You can't live without, and that's why lawyers exist, especially in this process, especially because it's in uncharted territory, especially because every state is different. So one question that I'm also going to touch in my class that I teach on surrogacy and adoption is the inheritance rights of the children who were born through IVF process. You have to realize that if the child is born to you through IVF process, that is your child, as if he or she were born to you naturally. Because it is your child, that child is going to automatically have the rights to inherit from you. If you don't want that child to inherit from you, you have to get together with probate counsel and make sure that that child is specifically exempted from your estate planning. But if you want that child to inherit from you, then you need to make sure that your estate planning documents is specifically list that child as your heir. To ensure that all parties who participate in IVF treatment or surrogacy process and adoption process are protected, I first ensure that every party has independent legal counsel, not only because that's what I do, but also because that is the law in the state of California. You have to have legal counsel that is independent legal counsel of everybody else who participate in that process. You must be represented. You must be represented independently by an attorney who is licensed in the state of California, and that's how we ensure that the integrity is complied with. Typically, if there's a change of mind or change of heart by someone or some people who have signed contracts for surrogacy and fertility before the completion of the process. The courts will typically look at, has there been damage done? Has the contract terminated? Has there been an excuse to the performance of the contract? Remember, it's a contract. It may have a different name. It's a fertility performance contract. It's an adoption contract. It's still a contract. And general contractual laws do apply. And that's why you need to have competent counsel, not counsel who does everything, but counsel who specializes in family formation to look at your contract, explain it to you, make sure you understand the ramifications of non-performance before you sign it. And only then, with help of that competent counsel, you should be signing that contract. One of the controversial things that should not be controversial in surrogacy and fertility treatments is the expenses, absorption of cost, and payment for the same. So one of the things that I teach in my class is the contract that everybody has to sign. And the portion of that contract talks about the cost, payment for the same, payment of the cost, and the responsibility of who is going to pay for which portion of the cost. If we're talking about a surrogate gets compensated typically for lost wages. It's an expense. A surrogate gets paid for medical procedures. That's an expense. A surrogate gets compensated for maternity clothes. That's an expense. A surrogate gets compensated for hospital stay. That's an expense. All those expenses are typically being provided to the surrogate by intended parents. So the contract has to specify what is being paid for, who it is being paid by, how much is being covered, how much is out-of-pocket cost, who is going to cover medical insurance payment, and also one of the things that we need to specify in the contract, who is going to pay for life insurance, because unfortunately, even today in year 2025, tragedy sometimes is unavoidable. And a surrogate may have an unforeseeable medical procedure, an unforeseeable loss of life, an unforeseeable expense that someone has to pay for. All of those things have to be negotiated in the very same contract that I've talked about that has to be signed prior to the commencement of the very first fertility treatment. The best advice I give to the couple who are thinking about doing IVF, surrogacy, and or adoption is that, first of all, please get information. Get as much information as possible because it is still very, very unknown. It is still very unpopular topic to discuss at your dinner table. But I will tell you again that there are so many people who are affected by infertility that it is mind-boggling that not a lot of information is readily available to those who want to know. But you really need to have information before you decide that that's what you want to do because it's expensive, it is heartbreaking, it is nerve-wracking, it is going to take your time, it is going to take your money, and it is going to take your heart if it's not successful. I'm happy to talk to you about this more. I'm here to answer your questions. I'm here to teach you about this industry. And please come to me if you have questions. Come listen to my class. Find me on social media. Email me, Zoom with me, DM me, Instagram me, however you want to get to me. I'm absolutely accessible. I'm absolutely reachable. And that concludes my next episode of Family Law Uncensored. I'm your host, Maya Shulman.